My name's Tom Cote, and is there any example of hardship that the board can give that you would approve? That you've been, over the past year, you've been making decisions on hardship, and they haven't met that degree that you need? Is there anything that you can give an example that would be acceptable? And
Okay, go ahead. I've actually been asked that question before, and based on, again, the ED 320, I was finding it very difficult to put an example together. But if I can defer to our attorney is willing to answer that one.
If you're willing to answer it, that's fine. If you want to comment on that afterwards, you can.
Just quickly, an example, and it's a very difficult standard to meet. There's just no question about it.
One answer doesn't define everything, so there's a lot of different things that can come into play. But
correct. Yeah, there are a lot of, but there is no question that it's a very difficult standard to meet. And so manifest educational hardship, in order to meet that standard. Examples would include, and there have been these situations where, and I relayed this to the superintendent recently, about a situation in another district where a young student was involved in an affair with an older individual who was prosecuted for that. And it became known to all the students in the district. And it was a very, very difficult situation for that young person. The person ended up needing serious medical attention, and it was simply impossible for that young person to even go to school.
Sure.
And so it was, and that, that's a classic case where a youngster cannot go to school. Some examples, and this may help you, because you need to know what has been ruled not a manifest educational hardship by the State Board of Education. It's almost easier to say what hasn't been than it is to say what has, because there haven't been that many cases, to be frank with you, under that very strict standard where someone has been approved as a manifest hardship. But there have been specific cases that have said that the general concept is that if a condition at a particular school is common to all students, so that's the issue of block scheduling, for example, versus not block scheduling. And that condition is true for all students, or all students in that school are subjected to the same overcrowding conditions. That's not a manifest educational hardship because it's not different than other students. Now, I'm not saying that's right, wrong, or different, or the standard that the board has to adopt. I'm saying that's the standard that's been adopted, and that's the rules that have come down. So, for example, it's particularly the case in extracurricular activities. One school has football, another school doesn't have football. It's manifest educational hardship for me to go to a school that doesn't have football because I'm going to be, football is my life and it's what I really want to do, and extracurricular activities are extremely important. Time and time again, the state board has ruled that that does not rise to the level of a manifest hardship, educational hardship. So that's an example. Specific courses that are available to one, that because all students have the same courses that are available to them. And now, because of the availability of, so specific courses are another example that has not been found to be an educational hardship, manifest educational hardship by the state. So it's a very tough standard, and you're absolutely correct. And that's the case.
So I just want to push you on this a little bit.
Okay.
Sorry, because I think, again, the state talks about manifest educational hardship.
Yep.
The school district policy that was adopted talks about educational hardship. And those two things are not equivalent, is my understanding. Not necessarily equivalent, depending on how the board interprets educational hardship.
Correct, they don't have to be. They don't have to be equivalent, but I think the point we've been making is that if it's not going to be equivalent, I think everybody's heard this, there should be some standard for the determination of what are the criteria you're going to use to make your decision.
Right, and I don't disagree with that, but I just want to be clear
That's
that
right.
when we're talking about manifest hardship, it's different from what the current JEB policy says.
Yes, but I also want to be clear that it's my understanding that the school board has since November specifically defined by its actions and its decisions that manifest educational hardship is what they meant by manifest hardship. And so they're applying now and have been, with the exception of the first case that they heard, the manifest educational hardship standard. Okay? So that's where it sits now, and the question here is whether or not it should continue. Right? Or we're hearing.
Okay.
So legally, you would recommend the higher standard? Is that what I'm hearing, a higher standard? No?
No, it's entirely up to the board to make that determination.
Okay.
I think there needs to be some standard that's adopted. I don't think my legal, first off, I want to make it clear, I did not review the policy.
Sure.
It wasn't sent to me because boards do that all the time. Boards adopt policies, and it's not a I did not adopt it before it was adopted. I did not review it before it was adopted. Obviously, I've seen it since.
Right.
And have some suggestions for improvement just for clarification purposes. No question about it. And I think that's clear, and I think everybody's revealed that. But I've not made an opinion. I don't have an opinion. That's a board determination. I can give you guidance about what it means, and to try and help a board identify criteria that will be clearly applied, easily applied, and are recognized by the State Board of Education.
So I'm a little confused because you seem
all right, one more question.
Okay.
All right,
Just because you seem to be saying that our contract states that all the students from Cote are supposed to go to Manchester. And so past boards, have they erred in allowing students to go out of district?
I think past boards have made decisions in accordance with the policies that existed at the time. So I think they've done that. And
So it's really up to the policies. It's not necessarily defined in the contract.
I think I've indicated to you previously that the contract indicates that all students will be attending Manchester schools, and there can be exceptions to that, and an exception implies that there's a reason for the exception. It isn't on a permissive basis.
Okay.
All right?
All right, thank you.
Thank you. I'm going to ask you to hold because I want to get to Mr. Curl and then 1, 2, and then.
I just have a quick comment on.
Yeah, but I'd like you to wait. All right, just.
I would just like to comment that, in my opinion, this board has failed again. Mr. Cote asked what a definition of education hardship was. The chair deferred to our attorney, gave you a definition of manifest education hardship. Again, the confusion. We are now asking you to look at our policy, which does not say manifest hardship, but we're asking you to believe that that's what we mean. As the attorney has pointed out, and the school board's agreed now, that we're going to use manifest educational hardship. First of all, I've never agreed to that. I'm a school board member. I have the current policy in front of me, and it does not say manifest educational hardship. If that is going to be the will of this board, we need to revise this policy to put those words in there. We cannot represent you by telling you that we mean something. It has to be in this policy. We have to be clear. That's the rubric that we need to develop here. I intend to do that. I intend to clearly state what this policy is about, and that is what we should follow, not change without bringing that policy forward. Thank you.